I want to talk to you about the process involved with an auto accident. What should you do first? Well, let's talk about what happens at the scene of a collision. Should you move your car? Washington State Patrol, police officers, 911 operators have you clear the scene, move your vehicle so that traffic can flow? Well, I think it really depends. If the liability or the fault of the other driver is clear, such as a rear end collision, I think it's fine to move the vehicles. But let's say you're on the freeway and the other car performs a unsafe lane change, they come into your lane. Well, it's foreseeable that once you move your car or cars, the other person can change their minds and say, wait a minute, you came into my lane. So in situations like that, I want to make sure that you take good pictures that show that you were established in the lane and the other car came into your lane and caused the collision. It's their fault. And at the scene, exchange information, certainly get their Washington driver's license, their insurance information, make sure it's current, take pictures of both vehicles, make sure you have good information. Otherwise, the safest thing is have the call 911, have the police come and document the auto accident for you. Now, once you're done at the scene, then what do you do next? Well, consult an experienced personal injury attorney. The consultation should be free. And then you can discuss liability, whose fault it is, what the next step is. But soon after the scene of the collision, I would suggest you consult an experienced attorney. The next step is going to be your property damage. I have a separate video on how to handle the property damage or the car damage for your vehicle. And then you get into, once you're injured, your injuries, you're gonna need medical treatment for that. So I recommend following up with your family doctor or your primary care physician. You may seek other modalities of treatment, other types of treatment, chiropractic, physical therapy, massage therapy, acupuncture even. But certainly with any of those treatments, make sure you are re-examined every 6 to 8 weeks. A couple of things. That's what the insurance company expects you to do. And also, this also reminds you to get your primary care physician involved every 6 to 8 weeks or so that you know you're getting the proper treatment. And as you are treating, make sure you update your attorney for any changes in your treatment. Certainly, if you have questions, ask your attorney as well. Now, during your treatment phase, there are going to be medical bills. And what happens to those medical bills? Well, if you have full coverage insurance, first party, including personal injury protection or PIP, then PIP is primary. They pay first. Once PIP runs out or is exhausted, then your health insurance is secondary. Certainly, there are options of receiving treatment on a lien basis as well, and your attorney's office can help you with resources in that respect as well. So it's very important to treat fully for your injuries so that you are 100% recovered. Once you're done treating, then your attorney's office should gather the remainder of your medical records and billing and put together a settlement demand package for the other insurance company. At R. Martin Law Group, when I send a settlement demand package to the other insurance company, based on your medical treatment and all your damages, I give them exactly 30 days to review the package, and then another 30 days, or a total of 60 days, I put a deadline on negotiations. I have found with experience, if you don't have a deadline on negotiations, insurance companies tend to want to delay, and who knows exactly when your case will be completed and you'll get a good settlement. So again, we put a deadline on your settlement so you know exactly when your case is going to be settled, or we explore other options. So if there's a reasonable settlement on the table, and your attorney advises you to settle, and it's your choice. You're the only person who can make the settlement decision. You're the only person with settlement authority. So you can settle your matter. The other option, if it's not a reasonable settlement, then you have your attorney file a lawsuit, summons and complaint. And once you file a lawsuit, then it can go a couple of different ways. One, it can go to mandatory arbitration, which is a mini trial, much more informal. And recent laws in the state of Washington have passed where most counties, Snohomish, King, Pierce, now mandatory arbitration is capped at up to $100,000 of recovery per claimant. So depending on the nature and size of your accident and your injuries, mandatory arbitration may be a good track to go on. The other is jury trial. Jury trials are economically challenging. So it's expensive to move forward with a jury trial. We are experiencing that a standard 4-day motor vehicle collision jury trial is costing my clients maybe $25,000 to $30,000 just in cost to go and complete the trial. So that's another consideration. In this office, of course, I advise my clients accordingly, and it really depends on the nature of your injuries, and if it's a catastrophic collision, sometimes you can only get true value from a jury trial. Thank you.